Hello, good evening and welcome to today's show. Today is the 21st of March 2024. It's Thursday, so you know that it's a Thursday edition of the show. You know already that every Thursday we look at the trending issues of the time, and we try to make some understanding, have some understanding of the issues and try and understand, what the intricacies and the nuances of the issues are, so that we can all be, as our president has admonished, citizens and not just spectators. The most topical issue today in Ghana is, what is happening in Parliament. This impasse between the legislature and the executive. Perhaps I'm broadening it too much. Perhaps it's just, a misunderstanding between the Speaker of Parliament in the person of, the Right Honourable Alban Bagbin and our President Nana Addo Dankwa Akufo-Addo. Permit me to read something to you. So, Ghana Parliament Speaker criticizes President for delaying the Anti-LGBTQ law. And I'm reading this, as background to our conversation for this evening. Accra, March 21st, that's today. Ghana Speaker of Parliament has said President Nana Akufo-Addo's refusal to act on an anti-LGBTQ bill for the time being was unconstitutional, and that Parliament would stop approving new ministerial appointments. One of Africa's harshest anti-LGBTQ laws, unanimously passed by Ghana's Parliament last month, has been on hold since the President's office said it would wait for the outcome of two legal challenges before the law goes to Akufo-Addo for assent. Okay, it goes on and on and on. I want to get to the relevant portions. It says, Speaker Alban Bagbin told MPs on Wednesday, that is yesterday, the President's office refusal to receive the bill was unconstitutional and caused an impasse between the executive and the legislature. He said Parliament would in turn be unable to consider the nominations. So what it means is that for 21 nominees to ministerial and deputy ministerial, positions, all of that has been brought to a halt. Now, this is interesting, very interesting. You have the Speaker of Parliament saying, I refuse to exercise my duties because I'm waiting for the results of, a judicial procedure. And this is because the President has refused to carry out his duties because he says he's waiting on the results of a judicial procedure. Interesting. And all of this started with this letter. Please, again, permit me to read this letter. It says, it has come to the attention of this office that while the President and other senior officials of the Presidency were at Peduasi for a cabinet retreat on Thursday, the 14th of March, 2024, you attempted to submit the Human Sexual Rights and Family Value Bill 2024 to Jubilee House for the President to signify his assent or otherwise to the bill. The office is aware of two pending applications for an order of interlocutory injunction, both filed on 7th March 2024 in the Supreme Court, and it specifies, the bills, one by Dr. Amanda Odoi, the other by Mr. Richard Delasky, pending the final determination of the matter. The Attorney General has, by letter dated 18th March 2024, informed the President that he has been duly served with both applications and has advised the President not to take any step in relation to the bill until the matters raised by the suits are determined by the Supreme Court. It is the understanding of this office that both applications have also been duly served on Parliament. Therefore, it would be improper for you to transmit the bill to the President, and equally improper for this office to receive the bill until the Supreme Court determines the matters raised in the suits. Indeed, it's a settled law that during the pendency of an interlocutory injunction application, the status ought to be preserved, and no action should be taken that would result in prejudicing the injunctive relief sought and undermining the authority of the court. This is perhaps the most instructive sentence in this letter. It says, in the circumstances, you are kindly requested to cease and desist from transmitting the bill to the President until the matters before the Supreme Court are resolved. Interesting times. Let me quickly introduce the three lawyers that I have with me in the studio to try and have some constitutional understanding, of all of this. I have joining us this evening lawyer Kweku Theodore Albright. Thank you for being here, lawyer. Always a pleasure. I have joining us lawyer Apia Dankwa. Thank you, lawyer, for being here. I have here in the studio lawyer Kwame Owusudanso. Thank you for being here, Kwame. Right. So, immediately, and I don't even want to discuss the bill, because I find that it could have been any other bill. Right? For me, the important conversation here is not about which bill. It's about a bill. It could have been any other bill, but it happens to be this LGBTQ family values bill that's in Parliament. On the surface of this, what do you make of this drama? This is the kind of drama that I like. I am overexcited about this drama. What do you make of that statutory lawyer?
Well, we operate in a democracy, and we're supposed to have separation of powers. And any attempt to morph into or plead into or prevent the operation of the other holders of powers then calls into question our very democracy. And so, while you call it drama, I would call it a very serious event. And it goes to the very core of who we are as a nation under the Fourth Republic. Really serious, because seemingly we have a tussle between the legislature and the executive. And these are interesting times indeed.
Absolutely.
I'll just leave it there.
Interesting times. Dramatic, serious, I agree, yeah. But also really quite dramatic.
Yeah.
Really quite dramatic. Lawyer, what do you make of all this? Wow, I'm going to be saying lawyer. Interesting.
So,
right.
So let me wish your lovely viewers a good evening, and my learned senior and my own good fellow, my learned fellow, a good evening. Like my senior here rightly said, these are truly interesting times in the constitutional development of our country. Yes, the fact of the matter is that in 1992 we chose for ourselves a constitutional democracy whose focus is safeguarding our liberties, right to life, our properties. Now, one of the most important tools that the Constitution uses to limit the powers of government is the separation of powers, as was rightly said by my learned senior here. The whole idea is to recognize the powers that the government wields, and then into which arm or into which institution you put those powers. Because ultimately, you don't want a situation where somebody or anybody has unlimited powers, because usually history has taught us that instances where people have unfettered powers, they tend to use those powers to abuse the liberties of their citizens. So the whole idea is, let's first identify the powers that the government was here. So in this case, executive powers, legislative powers, and judicial powers, and then put them in different arms. And the whole idea is that they believe that once you put them into different arms, then each arm will more or less serve as have an oversight responsibility on the other to more or less limit their powers for the purposes of safeguarding our liberties. So you have in some instances, and as when we delve deeper into the matter, you have sometimes the executive having some oversight over the legislative arm. You have the legislative arm having an oversight over the executive. You have the judicial having oversight over everybody, and the whole essence is to safeguard our liberties. So whenever you have such instances, and we've had a fair share of those instances here in Ghana. Talk about the Ria Kutu, talk about and Attorney General J.H. Mensah, and these were all instances where the extent of the constitutional democracy that we chose for ourselves could be expanded and then grow. And so I'm really, really excited, like as in, for those of us who also do dabble in some small politics, there's a rumble in the jungle, man. Backman versus Alfredo. But for the constitutional law students and for constitutional law lawyers, this is an opportunity for us to test and grow our constitutional democracy. So certainly these are exciting times in our country, and we should enjoy it.
Absolutely.
Yeah.
What do you make of this?
Well, I think this brings into sharp focus the principle of constitutionalism and how government is supposed to conduct itself in a constitutional system or in a constitutional regime. Ghana sort of practices some constitutional supremacy. So the constitution is that which we use in our, in our governance structure. So everybody must abide by the principles and the rules in the constitution. Now, it's also instructive to acknowledge that the constitution, that same constitution, grants powers, rights, obligations, limitations to the various arms of government which we have been educated about by seniors. Fortunately or unfortunately, we practice an executive system of governance. What it means is that the president wields so much power in its appointment and its disappointment, to the extent that the president can actually appoint heads of security agencies in this country, head of our judiciary. So the president has so much power. So the question becomes, in the exercise of the president's constitutional mandate, how is he supposed to exercise it? And if he exercises it, how do we determine whether he has gone beyond the peripheries of his powers or he's operating within the confines of the powers so given him by the Constitution? So that brings it to sharp focus the function of the executive and the functions of legislature, the functions of judiciary. And my seniors have demonstrated to you quite unequivocally, that the legislature and judiciary have a purpose, and their purpose is to check the executive because of the powers that we've given to the executive, the unfettered powers that we've given to the executive. So the president has all of that. The legislature must ensure that they act as a check on the executive. Vice versa, then the judiciary must also ensure that they supervise the activities of both the executive and the legislature. I think that is quite right. All of us know that. What is at play here brings into the forefront a conversation about whether or not the powers that the president wields can be exercised in a manner that does not find expression in law, in logic, and in common sense. And whether or not in exercising that duty, he can usurp his power into the fray of the legislature. Now, I say this because the core function of the legislature, pursuant to Article 106, my senior is here, is to make laws, and they make laws through bills. And the bills by themselves are not laws unless it is acted upon by the president, who is the leader of the executive. So there's some collaborative work that must be done between parliament and the executive in terms of the passage of laws. Now, if you read Article 106, it is very instructive because the usage of the words, I think, is very deliberate. It says that Parliament, in exercising its functions, by passing bills, those bills can only become law if the president has assented to it. So it says that, and the president or the executive must assent to it before it becomes law. So that operative word "and" is very instructive. So it is, so the work of Parliament and the work of the executive in terms of the passage of law must be collaborative. It must not be isolated. Now, when Parliament passes a bill, something happens. Now, if you read Article 106(7), in fact, there are various functions. You go through different processes, and I'm sure my seniors will be able to explain that to you better. But if you read Article 106(7) of the Constitution, it highlights a few things. One of them is that when Parliament passes the bill must be transmitted to the President, who shall actually use the word shall assent to the bill.
Right.
Now it explains three things. So the President can actually do three things. One, the President can decide to assent to the bill. Two, the President can decide to refuse to assent to the bill. Then three, the President can forward the bill to the Council of State. Now, between when the bill is transmitted to the President and the time which the President needs in assenting to the bill is 7 days. So the President has 7 days to make that consideration, whether to accept and to assent, whether to reject and to not assent,
right,
or whether to forward
pass it on.
Yes. Now, when it goes to the Council of State, the Council of State, I believe, has about, so pursuant to Article 90 of the Constitution, goes to the Council of State. The Council of State also has about, I think, 30 days or so to consider whether the bill must be assented to or not. And if they decide not to assent to the bill, so the President shouldn't assent to the bill, that is sent to Parliament with recommendations explaining to Parliament why the bill must not be assented to. So it baffles me and it leaves me in a state of confusion. Why the tussle? Because the Constitution is quite clear on the functions of Parliament and the functions of the executive in relation to the passage of bills and in relation to the assent of bills.
Pretty clear.
Pretty clear.
Pretty clear. Black and white. Pretty clear. Okay. So now let's come to the bill. I didn't want to come to the bill, but at this point I think we don't have a choice but to come to the bill. And we don't have to discuss the issues of the bill, but just to, look at the bill in terms of public perception, not in terms of the contents of the bill, right? I think that would be fair. Because of how very emotional the issues of the bill are, I think I shouldn't put you, in positions where you have to state what your personal, feelings about the bill are. So I'll leave that out. The point is that every Ghanaian appreciates that this is a very contentious bill. Very contentious. It seems all of Ghana is swaying towards one way. And I'm saying seems because there seems to be a very silent majority. That is pretty clear. There seems to be a very silent majority. And perhaps not so silent if you have individuals like Madame Audrey Gajepo, personalities like lawyer Akoto Ampao. I could mention, off the top of my head, 10 prominent Ghanaians who have put their heads literally, on the chopping board to say that no, there are things here that are wrong. Let's put a pause here. So this is a contentious bill. Now, Kwame has explained to us, the process, in terms of Parliament, in terms of, the executive, in terms of the legislature, in terms of the executive, what should have happened. I dare say those things are not happening because of how contentious this bill is. I dare say, for a wide number of reasons. We are getting close to an election. Every side wants to win this election. There are real financial implications. Let me read, please permit me to read, a line that I skipped in all of this, just to buttress the financial implications. It says, the decision to wait came after a finance ministry warning that the bill could jeopardize $3.8 million, billion rather, my paper said million, $1 billion in World Bank financing and derail so there's a 3.8 million in World Bank financing, and then there's a 3 billion International Monetary Fund loan package, and all these are in dollars. So clearly, there are very real financial implications at play here. I dare say this is the reason why our president seems to be playing a little bit of a footsie, with this bill. Okay. Now let's come to the substantive issue, the constitutional issues here. And again, permits me, I'm really doing a lot of talking today when I shouldn't be, permits me to take us into Parliament. I want us to hear exactly what it is that the Speaker said. When we hear that, I want us also to hear the majority's reaction to that, and then I want us to watch a video of the minority's reaction to that. So we have the facts, and then we come back and continue the conversation. Stay with us.
Honourable members, I also bring to your attention the receipt of a process from the courts titled Robson Nelson Eche K. Dafiamapo versus the Speaker of Parliament and the Attorney General, suit number J1/12/2024, which process was served on the 19th, that is yesterday, March 2024, and an injunction motion on notice seeking to restrain the Speaker from proceeding with the vetting and approval of the names of the persons submitted by His Excellency the President until the provisions of the Constitution are satisfied. Honourable members, in the light of this process, the House is unable to continue to consider the nominations of His Excellency the President, to use the language of the Attorney General and Minister for Justice, quote, in the spirit of upholding the rule of law, unquote, until after the determination of the application for interlocutory injunction by the Supreme Court. Honourable members, this is the precedent that is being set by His Excellency the President for all Ghanaians to follow. So any matter that comes before Parliament, any Ghanaian can issue a writ and follow it with an application for injunction. And that is enough to injunct Parliament from proceeding with the consideration of the business in the House.
Mr. Speaker went beyond expressing this disagreement and rather pronounced judgment on what in his view was wrong. Mr. Speaker did not only stop there, he also used very unsavory words to describe Mr. President. We believe that in a democracy, we have a right to disagree on views expressed, but we do not have right to say things to denigrate another. In any event, Mr. Speaker has always deferred to the leadership of the House to guide him in the conduct of business. This morning, the leadership of the House sat together to discuss the various items to be taken. We have finished some of them. There were some that we were supposed to take, and we're told that Mr. Speaker would have to take the chair. It's very disappointing that after Mr. Speaker had made known his own views about the letter sent from the presidency to the clerk, he adjourned the House Synod without giving room for the leadership of the House to even comment. This we find very strange. But this is a democracy. We believe, as Mr. Speaker himself said, and I'll quote him, that this impasse calls for reflection. This impasse calls for reflection. I will play that out to Mr. Speaker himself, that we all need to reflect on the way forward as a nation. He said he was not going into the matter as that would undermine the outcome of same. But we all know that the very issue that was raised by Honorable Dafemepo had to do with the continuing ministers who had been reshuffled to other ministries. The issue of constitutionality of certain nominees had been determined by way of they going through the vetting process, a report coming before the House for debate and final decision. So for me, these are two unrelated issues. How can the Dafemepo raise an issue regarding a minister who has been transferred? Let's put it in that state, that a minister in one ministry has been moved to another ministry. And the words used by the Mr. President was that he has relieved them of their portfolio and moving them to another ministry. How does that affect a situation where a nominee has been referred to a appointment committee? Appointment committee has vetted that person, brought a report, and you say that there's an injunction application pending. Therefore, such a situation cannot be considered by Parliament. This is bad faith. This is bad faith. Because you have two unrelated issues being conjoined to create a certain political effect. But again, since this is a chamber where we will do public business, we believe that we need to reflect on these issues and sit together.
We wish to remind His Excellency the President that just in case he has forgotten, that Parliament of Ghana is not an appendage of the executive arm of government. Neither is Parliament an extension of the office of the President. The Constitution of Ghana spells out in plain language when the President of the Republic of Ghana must do when Parliament passes a bill and present to His Excellency the President. The President must assent to the bill or must refuse to assent to the bill when it is presented to him as the President of the Republic. These are the only options, and in this case, there is no middle ground at all per the constitutional imperative. Ladies and gentlemen, let me also say that in the instance case of the Human Sexual Rights and Family Values Bill 2024, President Akufo-Addo has taken a strange and alien position which is unknown to the Constitution of the Republic of Ghana. Given that Parliament has been injuncted in a matter of the President's nominee for the position of ministers and deputy ministers, it is obvious that this Honorable House is also unable and cannot approve those ministerial nominees His Excellency the President has also presented to Parliament. At this point, the President may have to be innovative, dynamic, and think out of the box by downsizing the size of his government. Let me say that merely piling on numbers by way of appointing ministers and deputy ministers does not signal to the people of Ghana that the President understands the seriousness. But I want to urge that it is obvious.
welcome back. So, I mean, our lawyers are speaking a lot of law. Perhaps all I feel compelled to break it down, you know. So essentially, the bill was passed. The president was to assent. President is refusing to assent because he says the case is in court. 2 people have sent the case to court. So now Parliament needs to approve of the president's nominees, you know, his recently reshuffled ministers. Now, the Speaker of Parliament is saying, I also will not proceed because Roxanne, the Fiamapo has also sent that issue to court. That's where we are, in essence. That's where we are. I am unable to proceed. I like the correction. Because just like you are unable to proceed, with your hands being tied with judiciary proceedings, my hands are also tied because this one is also in court. This is you know, this is gymnastics. This is political, legal, constitutional gymnastics, isn't it?
But I think that beyond. See, when we break it down to president has to assent, and it makes it too simple. You understand? See, so the issue here, I think, was making the speaker a bit agitated, is the attempt of the executive to impugn on their independence. Because one of the cardinal principles of separation of powers is the independence of the various institutions of state. Now, when the president wrote the letter stating that the parliament should not transmit the bill to them, what the president was actually doing was to impugn or violate, that's the word, violate Parliament's work. Because Parliament's work beyond, as in, so they go and they pass the bill, and it's Parliament's job to then transmit it to the executive. The executive, under the concept of the independence of the various arms of government, ought not to have or should not have the authority, in fact, the audacity to even do anything to suggest to Parliament that you can do this, you cannot do that, because that transmission, the transmission of the bill is an act of Parliament itself. You understand? And so, for the president to write a letter telling them not to do their job.
In the circumstances, you are kindly requested to cease and desist from, desist from transmitting the bill to the president until the matters before the Supreme Court are resolved.
Trust me, if I were,
you are saying that take this phrase out of the letter and it would have been okay. Is that what you're saying?
You see, so there is indeed an application for injunction. We are not here to go into the merits or not of the application Now we all know that it strikes that an application or a notice of an application of an injunction works as if it were an injunction.
Right.
You understand? So without even going into the merits, the fact that the presidency have been served with application of injunction, yes, the president can on that basis put a hold on his act. Because his action, his supposed act is to assent or to refuse or whatever it is. That is his act. So, but the mere fact of that does not mean that you have the authority to tell Parliament not to transmit. And that's where the problem comes in. So merely you do that, and what you are doing is to violate Parliament, is to go against the independence of Parliament. And that's what has egged the speaker rightly.
Number three.
I told you before. For me, see, we shouldn't see the speaker in the eyes of our partisan political considerations. As maybe is a protest action he's taking, but it's a protest action he's taking to protect the integrity and independence of Parliament for our own good. Because if we sit down for anybody to violate Parliament and reduce Parliament to nothing, then the very essence for which we chose for ourselves, constitutional democracy, protect our liberties, protect our lives, protect our properties, will be undermined.
Okay, hold on, Kwame, before you come in. Right.
The Attorney General's letter to Honorable Alban Babe is to the effect that respects the courts.
Right.
Right?
Right.
But in the same vein, you are telling Parliament to disrespect itself by refraining from transmitting the bill to the executive. So, in my estimation, that letter, which was written to Parliament, should have been written to the President. Allow Parliament to do its work, pursuant to the Constitution. Transmit same to the President. Then you injunct the President. Do you understand? Injunction on Parliament, yes. Because, no, there is a purported injunction for the transmission.
There is.
A purported injunction on Parliament. Hold on.
Is there?
Hold on. You see, I listened to the Attorney General. Now, he said that the injunction is built on 2 legs, or maybe more. But the first 2 legs that he spoke about, one was the transmission of the bill by the clerk of Parliament to the President. Then the second one was to restrain or to ask the President to refrain from assenting to the bill. Do you understand? So
have you seen the?
No, he said it. I listened to him.
Because
it would be very strange.
Because the letter of
for me, if that's what it is.
The letter of this letter.
Right.
No reference is made to any
transmission.
Purported injunction application
on transmission.
On transmission.
No.
So
I listened to him when I was driving. I was listening to him on Midday News on a platform. I don't want to mention the platform's name, but it's a very credible platform. He was interviewed. Dafemeko was also interviewed, and I listened to him, and it was very clear that Parliament could not have because the question was asked whether or not he was preventing the clerk of Parliament from doing his job, right? And then he said no, but the injunction application was to the effect that Parliament should be prevented from transmitting.
It even makes the matter worse.
Yeah.
You see, is it a duty of, if indeed Parliament has been served with an injunction application, is it a business of the President to write this letter to Parliament?
Exactly. So that is where the battle for supremacy is. Because I told you.
I think the judiciary is perfectly okay to flex its powers and flex its muscles.
But senior, I need more. Maybe I need more education on this. Once an injunction application is filed and it has not been granted, prior to that, what can happen?
No, so
you see, it's not automatic.
No, listen. There are numerous.
Exactly. Schools of thought.
There are numerous authorities in Ghana.
Yeah.
But think about it. So even without any authority, I can mention Mufat. I can give him a lot of authorities. It's so clear. See, you are not supposed to do any action that will prejudice the judiciary's actions. Yeah. Now, if there's an injunction application, you go ahead and deal with the subject matter of that application. Have you not rendered the courts useless?
But no, I get your point.
Have you not undermined the ability to do justice?
By law, is there anything?
And I'm not authority. So by law, we know in Ghana, the what's called decisions of the courts are law. I'm giving authority, Mufat. So there's authority. There's so many authorities. Mufat. You see, which says clearly that a notice of an application for an injunction is good as it will stay.
I agree with you. A notice of an application injunction on e-levy was flagrantly violated.
Disregarded.
Yes,
disregarded and disrespected. Do you understand what I'm saying? So I'm not saying. So is it in all cases?
No, it should be because when it was violated, did anybody take steps? People who made that application, did they take? Well, you know that the court won't come by itself to take a matter and hear it. You must always, send matters to court. So when somebody had violated this clear rule, it was the duty of the parties to have made a contempt application in court.
So the 11th commandment, that shall not be caught. That's what I'm saying. I'm saying that in the absence of, you understand that's what I'm saying.
So it means that all the steps that have been taken by the AC and the response from Parliament is actually at variance with the injunction application. Because if the application, the notice application has been made, right? Yeah. And then you find the Ministry of Justice writing to Parliament to say that because there's an injunction, refrain from doing X, Y, Z. Are you the one to tell Parliament to do that? Or naturally, the rules must operate so that Parliament will be aware of it.
But you see,
so are you not taking a step in that process?
No, but if you see Governor Dam was in the Attorney General's role, he's supposed to be an advisor for government, not just for the executive, I'm sure also for parliament.
Yes,
so he can
For all of the organs.
so he can advise parliament. So I don't have an issue with the president if he advises, but I have an issue with the executive trying to tell parliament what to do.
These are interesting times. Hold on. Let me make it the situation even further. So you have the majority now holding the position that the spirit of the president's letter is conclusive, that the president is constitution-minded and will not undermine the Supreme Court of Ghana in its sacred role of administering justice. The president was in no way being dictatorial in his communication to Parliament, given the fact that the content of the letter was not binding on Mr. Speaker. This muddies the waters even further.
So let me say this, that the last paragraph should not have come. That was most unfortunate. Instead, a letter should have come from the executive to say, we feel constrained or we are constrained, and for that reason, we will stay all action until determination has been arrived at. At that point, Parliament is okay, the executive is okay, and then we wait for the determination. But to add the last paragraph murkies the water. And then with the reading of this letter, it further murkies the water. So if that is the case, why was the letter sent out in the first place? Why was it sent out in the first place? With the last paragraph in check, I think perhaps advice should have been taken, or it may have been an off day for whoever wrote the letter to send it to Parliament.
Right?
Yeah.
Right. Because if it is not binding on the Speaker, you don't use words like cease and desist. This word that I suffer with.
Cease and desist.
Desist. You don't put it in there if you know that it is not binding on Mr. Speaker. Perhaps Mr. Speaker knows that, well, it is not binding on me. Let me show you that it is not binding on me.
Yeah.
Right?
And that last paragraph is, in a way, unintentionally causing a constitutional crisis. Unintentionally.
Right.
Unintended.
Right.
Causing a constitutional crisis.
Right. This is a constitutional crisis.
I had a conversation with Kwame.
Right.
Kwame here, about a month ago. Kwame, you promised that you form some movement. I'm here to hear from you.
Yeah.
But this issue raises the conversation we had. See, because of the nature of, as an architecture of our constitution, the governance system, for whatever reason, the majority or the party that sponsors the president, and let's say, as in his members in Parliament, always feel that they need to support the executive as against their core mandate, which is to check the executive. You understand? Because because you see, the very essence of what the majority are doing is to undermine Parliament's work.
But I would say two things. The first thing is that the second letter is an olive branch to say, let's pull back, because it was ill-advised.
You mean the majority's letter?
Yeah.
This one?
It's an olive branch
Right.
to say, let's pull back, because I think we overstepped our mark. That's number one. But number two, when you talk about the members in Parliament supporting the executive, it is very typical, especially when you have a whip or a chief whip, whipping all of you in line. Otherwise, you as a member will be caught out in the cold.
So, Council.
So then, are you a member of the executive or you're a member of the legislature?
Isn't that the point? Because if we say democracy is representative, and then so my MP, I am Okankwe South.
Yeah.
So I'll go and vote for my MP. Who does my MP represent? Does he represent we the people of Okankwe South, or he represents his party? Does he represent his party or he represents us? Because the whole idea of representative democracy and why we have parliament is the MP is supposed to be representing my interest. We understand that you are sponsored by a political party, so there's a fine line. So between your political party and then check out for my interest. Or the whole essence of this, the whole purpose of our constitution is to protect my liberty, your liberty, our liberties. That's the whole essence. You understand? So the powers that the constitution created and distributed, the system of causing one arm to check the other, of liberty that powers, is for the purpose of protecting and safeguarding my liberty, my life, my property, essentially our interest. So where you are a parliamentarian and you are not, because like this letter, the letter the majority gave as against the position the speaker has taken, because clearly the position the speaker has taken is a protest position guarding the independence of parliament. Right. So if the majority caucus write this letter essentially to justify the acts of the president, that he's not being dictatorial, what else they say, it is undermining the speaker and parliament at whose expense? Not at their expense, at my expense.
Okay, so
very good question.
There's a debate,
right,
and there's a perennial debate as to whether when you elect your member of parliament, he goes there to represent you directly, or you elect him as a mind who goes there and acts in your best interest. Okay, and there's a clear difference between the two. Am I representing you directly, or do you elect me knowing that I am a sensible individual who will go and with my own mind will take decisions? And that dichotomy always exists because that MP is a member of a party, all right, and he represents that party. At the same time, that party is that party and that member stands and obtains the mandate from the people. The question is, do I go there to be the voice, mouthpiece of the people, or do I go to be my own voice, knowing that I am your representative? And that choice needs to be clear, and it's never clear.
In fact, fantastic point. Wow. Yes, so, and that's why I keep on saying, so what is the principle behind certain steps or actions the MPs take? You understand? And I'm saying it categorically clear that when these are MPs, you understand, as I've experienced them for the past 30, especially under Nanado's watch. Majority of the MPs, especially the MPP MPs, when they're taking the decisions, their sole consideration is their party.
It's none of these two considerations.
No.
It's not these two considerations. Not the people, not themselves, but the party.
It's just to catch the eye of the president and probably His Excellency.
Please allow me to read this.
It's nothing concerning.
Please permit me to read this. And this is and Lawyer, this is in reaction to you saying it's an olive branch, and I'd have appreciated it if it were an olive branch, because then, olive branches in situations like these, they soften the waters, they make it easier, to navigate. However, the 13th paragraph of the letter says the NDC is bereft of ideas. They do not have any credible alternative solutions to the problems of international dimensions facing Ghana's economy. The poverty of the NDC's political posture is clear and obvious, and Ghanaians will not return them to power come December 2024. This doesn't sound like an olive branch to me.
But this has nothing to do,
with nothing, actually. This has nothing to do with nothing.
Senior,
nothing to do with nothing.
Senior, trust me, this is for,
right.
See, we've sat, at least, I was 11 years when we started this 1992 constitutional dispensation. We've seen them for 32 years. And I'm so fortified in my mind that their interest is not, because you see, let's say if even you gave and you did so beautifully the dichotomy, you understand. Now you don't want people who are independent minded, but even in your independent mindedness, it should be guided by certain considerations. And for us, yes, be free to speak your mind, but you should be guided by the consideration being what is in the best interest of the country. You understand? And what is in the or in your argument or in your parliamentary job, you took a vow, the president and the MPs, to protect the constitution. Now, to protect the constitution also means that you are protecting the purpose for which the constitution was adopted in the first place. Now, this, we took upon ourselves a constitutional democracy. Yes, and that's why you read the constitution and you see what's called tools, all the tools in constitutionalism, separation of powers, judicial review, the principle of natural justice, all at play in this constitution. Right. Rule of law, as in reducing the use of discretion power. Our constitution is one of the few constitutions in the world where you see clearly governments, the constitution limiting how or dictating how discretionary powers ought to be used. Because the focus clearly was in limiting the powers of government for what purpose? To protect our liberties. So that when you are presumably these are MPs, they are smart. I can tell even me, I'm not an MP, I'm not an MP. You understand? I know the position the speaker is taking is a protest position.
Let's hold on.
It's a protest position to protect the independence of Parliament for what purpose? Because once Parliament's power, Parliament's independence is undermined, then the whole focus of limiting powers of government to safeguard our liberties is also undermined.
So then my question, and I like the way you have taken a firm position. In your mind, you have no question in your mind that this position by Speaker, safeguards
is
the legislature and ultimately safeguards the liberties of the government. Okay, I am not so sure. I'm trying for us to get there. I like the fact that you are, and I'll come back to you in a minute. Let me come to you. It says Parliament will be unable to consider the nominations, 12 nominees. My question is this position constitutional? The position of the Speaker to say that Parliament is unable, to consider the nominations, because Parliament has a right to make sure that today these people are in office and working. Is that position constitutional? This position by the Speaker, is it constitutional?
So I will ask you a question in answer to this, your question.
Right.
Parliament's power emanates from where? Emanates from the Constitution.
Right.
And someone has gone to court asking the court to injunct a process in Parliament. Parliament cannot go ahead and act and violate another arm of government, that which they are seeking to protect. They are trying to protect their independence. So it will be unwise for Parliament to undermine another arm's independence. So they have to respect the courts. Now,
so for you, it is constitutional.
It is constitutional.
Okay.
As to whether, and it is constitutional to the extent that and I've read the statement of claim, okay, and I'm not going to go into it. I'm just listing or itemizing the things which Dafia Makwa has put forward. And he cites Article 78 and Article 81A of the Constitution. And those are in respect of a vacant ministerial position and what ought to be done, and new appointments and what ought to be done. And now I asked a question this morning as to whether or not we have over the period been very strict in adhering to the provisions of the Constitution, or we have been liberal in adopting a convention which we have been operating for now, right? Because on many occasions, and my senior can bear testimony, we have had situations where, and that is why it was not a subject matter for debate when Kojo Ponkruma, Honorable Henry Korti, and all those people started working, and nobody raised the question, nobody asked them anything. Because if you want to be strict in explaining or interpreting the Constitution, pursuant to 78, then you will say that because they have been reassigned to a different ministerial portfolio, they ought to be vetted. I mean, Singer disagrees with me on that, because he says that there's no mention of,
it's not clear.
But I am very clear in my mind that if you have been appointed to a specific ministry, even the questions that are asked of you are specific to that ministry.
I agree.
So if tomorrow you have been reassigned to Ministry of Energy, the questions that will be asked of you are different.
Right.
And the answers that you will proffer will be different from the answers that you
show
gave.
Competences
Exactly.
for that
the
specific ministry.
So I think that if we wanted to strictly interpret the Constitution, then Honorable Henry Cote and all those people who are in office now, in my estimation, my humble estimation, should not be working, and they should have been vetted. And that is why it is captured in the statement of claim of Honorable Dafia Mepo. As to whether or not that is going to set a precedent which may in the future affect Parliament in its own operations, I do not know. But in terms of the constitutionality of it, right. I think that is grounded in law and it's grounded in the provisions of the Constitution. Now, it's also very instructive to note that these appointments, you see, and I'm going to be very candid here. Yes, Parliament is protecting its sovereignty. Parliament is protecting its independence. And was it you or Senior who said, but at what expense? For whose benefit? Because the people who are in Parliament today, I term them as representational. They are representing over 3 million Ghanaians in Parliament. So whatever decision they take must be in consonance. 30 million, yes. In consonance with the minds of the Ghanaian people. Failure of which would mean that you have disrespected the good people of Ghana. On the basis of that, I would have thought that even though the president has refused by reason of an injunction to assent to the LGBTQI bill, for which reason we are upset, we would not go on that tangent because we are serving the interests of the good people of Ghana.
But Kwame,
see, and let the Ghanaian people be the judges of the actions or inactions of the president.
Kwame, you just contradicted yourself.
I have not contradicted myself.
You already started by saying that their position is constitutional.
No, hold on. Oh, then you're not listening to me. I'm looking at the issue from two perspectives.
Right.
I'm looking at the issue from the perspective of the strict application of the provision of the Constitution.
Right.
And I'm saying that if you look at it strictly, they are right. I'm saying that. Right. And then I came back to tell you that, however, in strictly applying the provision of the Constitution, okay, is it in the interest of the Ghanaian people, especially where we know that in the past, by convention, people have been allowed to occupy those ministerial offices and have been operational.
Perfect.
So that is the argument I'm making. And
I understand you.
Seniors will tell you that it is not all the time that the law is operational. Sometimes convention, even if the law is clear, convention is applicable.
Kwame, I completely agree with everything that you're saying. And for me, you jump straight to the meat of this conversation. And the meat of the conversation for me right now, one was to decide who is being constitutional in this. Is it the legislature? Is it the executive? I think we have agreed that it looks as though the legislature is being constitutional.
No.
Am I right?
All of them are being constitutional.
Yeah. Is the executive being constitutional?
Yes.
The executive being constitutional.
Yes.
Okay, great.
To the extent
that it is respecting the court.
To the extent that you
No, Kwame, I disagree with Kwame.
Okay. I need us to have some clear cut facts. Yeah. Hold on. Let's listen to lawyer rights first.
So to the
my lawyers.
To the extent that you take out the last paragraph. Then.
But the last paragraph is part of the letter. We can't take the last paragraph.
So that
we cannot.
Okay. So if you took out the last paragraph and said we are injuncted and therefore we are waiting.
We won't do that.
That's not a problem. To go beyond that and have the last paragraph, that provides a problem. But the subsequent letter, I mean NDC or no NDC, the subsequent letter seems to be saying actually that last paragraph wasn't a mandatory statement, but it was merely commenting on a given situation, especially as it says, can you read it as it says kindly? I mean, you don't use kindly as legal language. What does it say again?
Give me a second. Right. It says here, the spirit of the president's letter is conclusive that the president is constitution-minded and will not undermine the Supreme Court of Ghana.
No. I'm talking about the letter from.
It's not binding. It's not binding.
The letter from
the majority.
From Jubilee House. The last paragraph of the letter from.
The problematic letter.
Yeah,
it says, in the circumstances, you are kindly requested to cease and desist from transmitting the bill
so
to the president.
The kindly and desist don't sit.
They don't.
They don't sit together at all, and that's in a sense. It's not legal language, all right? It's not legal language. So once you take that bit out, then you can say there are two arms or two legs to this letter. The first is the interaction with Parliament, and that was off. And then the interaction in respect of the court, that is on. So in respect of the action between Jubilee House and the court, that is constitutional. In respect of Jubilee House and Parliament, that is not constitutional.
Yes.
In respect of Parliament and the judiciary,
okay.
That is constitutional.
Yes.
So once you disaggregate the issues, the only offending bit
is Jubilee House to Parliament.
Is Jubilee House to Parliament.
Absolutely.
And it's in the last sentence. And it's in that last sentence. And it's in the last sentence.
But he said what day, because that letter, everything written there was just interesting. All what they meant to tell them was the last bit. That
kindly desist.
Kindly desist. What essentially you not write letters. You do all the jargons, but what you
it's in the conclusion. That's why you summarize the import of your letter.
Desist. And I agree. It's unconstitutional. They don't have the power.
No, I agree.
The executive do not have the power to write this letter.
No. Executive in terms of
Kwame, why would you
because hold on, the Minister of Justice is part of the executive.
Hold on.
I'm talking about not to.
Yes, so you need to clarify.
I don't need to
because you
explain. The president wrote a letter to the
legislature.
The president has not written any letter.
The letter was signed by Nana Bediatu as secretary to the president. No, Kwame, let me ask you a question. Where would you put the import of your letter? You are writing a letter to Parliament. Where would you put it? Where would you put the stress? I find the stress of this letter
I think that
in the last sentence.
I need to be very clear.
The import of the letter is.
I think I need to be very clear, and it's as dramatic to all of us. I have not said that the executive acted
correctly
in good faith. Okay. I've not said that.
Not good faith.
I am saying.
So not in good faith, not constitutionally. Okay.
I am saying that in part, the executive acted constitutionally by reason of it deciding to refrain from assenting to the bill because the case is in Parliament.
Right.
No, it's in court.
It's in court. Thank you for the correction. Do you understand?
Yes.
So on the basis of that, the executive had acted constitutionally. That's what I'm saying. But in respect of the letter that was, whether the last paragraph, the opening paragraph, the middle, whatever, even the mere thought that you could write such a letter to Parliament was in gross violation of
that writer could have been saying that we find ourselves in an impossible situation, and that is why even if you transmit, we will not be able, the president will not be able
to. Senior, you should be charging them because what you're doing is giving them free consultation. You should be charging them. Contact them what they did. And we are not telling them what they should do.
The whole show is free consultation.
The fact of the matter is that, and you see, it's not about how the president, right from day one, he's been running away from assenting. So we all know that the president doesn't want to assent. You understand? That is not the issue. The issue is what has gotten Speaker. Because Speaker seems to be very angry. Is this letter? This letter that is, and so we shouldn't try and run away and veer into other things. Let's focus on this letter.
Right.
And what this letter is doing is one arm of government trying to order another independent. of government to
impunity.
refrain from this.
The impunity.
And that's the
issue.
issue.
Is what
that issue
makes
is not
it,
about that. That's everybody in Ghana. My 4-year-old son knows that the president wants some corner to run away from this bill.
From the bill.
And he's not doing very...
Which brings me to the conversation.
He's not doing that, but
right.
at the end of the day, I want our position to be heard, loud and clear. I don't want any confusion. My position is that this letter, the letter from the Flagstaff House, that letter that has the cockroach audacity to order another arm of government is unconstitutional. And we shouldn't be afraid to say so.
Right.
Because what is at stake is the purpose for which our constitution was made in the first place. That's our liberties. You understand? So we shouldn't.
No. I don't think that we must belabor it because I think all of us are not in doubt.
No, it's not about you. You let me say our position. I want it to be clear.
I think that across what we've agreed
my senior here wants to be very magnanimous. He's giving them free advice. Please charge them and give me my share. If you want to charge them, give me my share. But I want to. You see, we shouldn't allow that kind of thing. You understand? You all know that for whatever reason you want to run away from the bill. You understand? And you are destroying our democracy.
Hold on. You've made the point. I think the point has been made. Kwame has made the point. Lawyer, you've made the point. You've made the point that the spirit of this letter, one, is unconstitutional. The letter of it is the letter of the letter is unconstitutional. The spirit of it is not in good faith. I think we've made that.
The spirit is also unconstitutional.
No, I said unconstitutional before. Even the spirit is unconstitutional. Okay, I agree. So we've made that point. That point has been made. Now let's move ahead. We have also agreed that the speaker's position is constitutional.
Yeah, excellent.
Right?
Excellent.
How do we move forward?
They should be right then. So one.
Because this is an impasse. How do we move forward?
I don't think it's an impasse, to be honest. I think it's just...
No, Kwame, it's because the president will not...
It's not an impasse. It's not an impasse.
Okay.
No, hold on. With respect,
listen to what she's saying.
No.
Listen to what she's saying.
Okay.
On the face of it, it's on the face of it.
It's not. Let me explain.
On the face of it, it's not an impasse. On the face of it.
Yes.
But we all know that.
The president does not want to accept.
The eligible to say no something. Definitely, but go and put something in. Let's muddy the waters. I'm telling you.
You see,
this is political gymnastics.
Yeah, that is where I was coming to.
So there's an impasse.
I made this statement this morning, and I said that what is the purpose of Dafiamepo going to the Supreme Court to injunct the proceedings of Parliament today? What's the purpose?
He wants to be constitutional.
Yeah, that's all.
Do you understand what I'm saying? It is an attempt to respond to the president. To tell the president that if you have failed to sign the LGBTQI by reason of some injunction that has been placed on it, then we are also saying that the people that you have appointed, we are going to injunct their approval. That's it. But you see,
who suffers?
But that is the question. You see, and it must not be lost on us at all.
Yeah.
And I'm very particular about the sufferers of the decisions by these people. Because in the final analysis, I expect that the ministries must be operational, must operate. In the final analysis, I expect that there must be a minister in charge of energy, a minister in charge of interior. That's it. That's all I care about as a Ghanaian. You see, this political gymnastics and retaliation does not serve anybody's interest. I agree that yes, Ghanaians want the LGBTQ whatever assented to. I agree that they want that. But is this the only way to respond to the executive? Is it the only way?
Yes.
Do you understand what I'm saying? No, is it the only way?
Which other way?
Because you see, this is a government that has told you that because we do not have money, and because it will be practically impossible to get the last tranche of the cash from IMF, we will not, invariably, sign this bill into law.
But
you've been told.
Respectfully, when did the IMF or the World Bank come and tell the people of Ghana that
it's open to you?
No, Kwame, hold on. Let's have one conversation. Let's hear you, lawyer.
So when did the IMF or the
lawyers,
World Bank,
you're out of order, please.
Sorry.
When did the IMF or the World Bank come and tell us categorically that Ghana, you will suffer because you have signed into law the LGBTQI plus legislation?
I don't think we've had any formal communication to this effect.
Zero. No formal. And so it is questionable whether that is the case. That is number one. And even if it were, then the second question is, at what point does the sovereign will of Parliament representing the people of a sovereign nation kowtow to a bank because it is threatening to withdraw financial
subsidies
aid?
I will not get into that conversation only because, like you yourself say, please hold on, only because, like you yourself say, there's no communication, official or otherwise, to back that. We've been told, but from whom? Who told us? Who told us?
Government that it is injurious. I think Mr. Albright, I think you've even mentioned it.
No, we've heard.
No, but I say,
where is it from?
made a statement.
Made a statement based on what?
So we should the finance minister.
But
this is rumor mongering.
It's not from government. What are you talking about?
At best, this is rumor mongering.
It's a serious matter.
How did you see the memo?
Don't.
How did you see the memo from Ministry of Finance?
No. But what is the source of that memo?
The primary actors in this case.
Is the IMF or?
The primary actors in this case.
I'll say that.
The primary actors are the government of Ghana and the banks, IMF or World Bank.
World Bank.
And the World Bank has been put to strict proof. A request has been made asking them whether at any point they have issued an encyclical, a letter, or made a statement which says, this is what we will do if you go ahead and sign the bill. And to date, the silence is deafening. And so is this an attempt to avoid the bill being accented to? Or is this a real situation which we have on hand? And then in any event, even if it were true, you then come to the second issue of
sovereignty.
How does a sovereign nation react when the majority in the country are in favor of a particular legislation and that has to be stalled? Question mark.
Right.
I'll stop there.
I appreciate your question. My only concern is that I will not take it that far. What if, because the IMF, any of the other of demands, we haven't heard from them. So for me, that question then, we are not there yet. Hold on.
We are there.
Hold on, Kwame. We are not there yet because what if somebody is just saying something?
Okay, let me read
it. Would you ask me a question based on something that I have not said, a position I have not taken?
There's evidence to back it. You see, this was issued on the 4th of March 2024. BBC, you cannot see it. Ghana's finance ministry urges president not to sign anti-LGBTQ bill.
Right.
It reads, Ghana's finance ministry has urged the president not to sign a controversial anti-LGBT bill passed by parliament last week. It was the country could lose a total of 3.8 billion, that's 3 billion pounds in World Bank funding over the next 5 to 6 years. And then it goes on and on and on.
This is the finance ministry.
This is the finance ministry.
Yes,
finance ministry is an arm of government.
No, hold on, Kwame. The finance ministry would take a position. I appreciate that. I'm saying that. Shouldn't we hear from the IMF? Shouldn't we hear from the World Bank?
Who would you rather trust?
No.
Who would you rather trust, your government or IMF?
Hold on, Kwame. This is a government that does not want to assent to this bill.
You're not getting the point.
Kwame, hold on. Let's take it one at a time.
With respect.
One at a time. One at a time, please. This government doesn't want to assent the bill.
You don't know.
1 minute the government says, if we assent the bill, we are losing money. Another minute it says, my hands are tied because of an injunction. Another minute it will come and say something. All I'm saying is that, for me, I'm not at the point where I will impugn motives attacking my sovereignty until I know for a fact. That's all I'm saying.
What is motive?
That's all I'm saying.
Because
clearly, it seems to me, and I stand to be corrected, that this government will hang on to anything not to assent.
Yes.
Can I just add
this bill.
I love the fact that you read from BBC, but the BBC was reading from the finance ministry, okay? It was not saying the IMF say, it just says the ministry urges the government not to assent to the bill.
Isn't that interesting? That the ministry would have to speak through the BBC to the government of Ghana not to assent the bill.
No, the BBC
isn't that interesting?
No, the BBC was merely reporting.
I appreciate that, but isn't it interesting though?
The point is, to this date, the BBC have not come out to say, the IMF say, actually, if they do, we will do this.
You see, the point of departure for me is that it is the finance ministry that is in negotiation with IMF. So if two of us are in the room and you have a position, but you cannot come out with your position because of where you find yourself, and because you don't want to be seen by outsiders as people who are forcing something on the Ghanaian people, what would you do? You simply tell the Ghanaian people to come out.
A hypothetical situation.
No, I am not. I am telling you that the finance ministry that is negotiating with IMF is telling you that
I appreciate what you're saying.
Because then they see but whatever the case may be, for whatever reason, government thinks that if it assents to the bill, it's going to lose money.
Right.
So whether the IMF has said anything or
has not said anything, this is government's
the government
belief.
believes that. They are sent to the bill, and its impact.
And doesn't it interest you why government believes that?
Hold on. Is it that
That's
they
interesting.
believe that?
That's interesting.
Is it that they believe that, or they are telling us that? And there's a difference.
No, but senior.
No, telling us something.
For the first time, we have a situation where the president is refusing
to sign a bill. That means
the first time.
There's something holding it.
You see, and that's the discussion we have, because if the president, Kwame, in his initial statement, gave the three scenarios. Right. Either you assent, either you refuse, or you push it to council. Whichever way you look at it. At the end of the day, the bill will be assented to. Because if you refuse, in 7 days, you must give reasons
you
why.
You must be impeached. Yeah, you can be impeached.
You must give reasons why you won't assent. And then it goes back to Parliament. And when 2/3 of Parliament sign, you don't have a choice. That one you must assent. If it goes to Council of State, whatever, it will still come back to Parliament.
With recommendation?
A recommendation, and you understand? So if the president right now is resorting to injunction,
judiciary,
right, that means that the president is desperate not to assent to a bill, and that's the first time it's ever happening. So then the question, why is the president that way? And then just this last point. Then you have a situation where the finance minister himself, ministry, by way of a memo, is advising the president don't assent. Not to. Because if you assent, you will lose 3 points.
Not to.
And certainly, for the first time, I don't recall any point in the history of this country where the assent to a bill has become an issue. Because it's like a matter of course, but for the first time, it's a huge issue. The president is certainly resorting to judicial gymnastics to avoid assenting to a bill. And so the question is why?
And the question,
why?
And the why can be answered by the visit by Kamala Harris. And when Kamala Harris stood next to the president, what did the president say then about the bill?
I don't know. What is it?
I think we ought to play
because the president, what I recall is the president also stated in church that what's called LGBT won't become legal under his watch. So if he says something else under Kamala Harris, I heard his comment saying that our friends from there. You see, certainly for me, in my view, there are issues in the bill for which reason I was hoping that the president would be bold to refuse the bill and state what issues he has with the bill. Because the issue of whether gay or not is illegal. Sodomy is already illegal in Ghana. But there are issues that borders on our right to freedom of speech.
Free speech.
There are issues that borders on our right to free speech, which are some of the core principles that underpin our constitutional democracy. Yeah. Is this not an opportunity for you, the president, to say, listen, not even outside, but subject to you reviewing these clauses in our constitution, which, as for all intents and purposes, is at variance to the spirit of our 1992 constitution. You understand? But the solution is not in this running away. But what he is doing is running away from leadership. we should tell him, because we took what's called a vow to protect our constitution. It's a vow to protect our rights to free speech. It's a vow to protect our right to free conscience. So if there is any law in this country that seeks to take those rights from us, then it's your obligation as the president of Ghana, through the power of assent or refusal of assent, to say, listen, I'm refusing only because I think you should have a look at the attack on free speech. The solution is not to run away and attempt this injunction gymnastics.
No, by the same token, then if Party A or Party B then takes on that role, this is what I was going to complain about in any event, but that third party is doing it for me, so I no longer need to raise those issues, because those issues are those issues. Those issues.
I'm not so sure.
Those issues.
I'm not so sure. That's what's happening. I'm not so sure. Only because lawyer. I think lawyer asked my question for me and answered my question for me, because my question was going to be, why would he not just take a position?
Yeah.
That was really my question. No, but the point is that lawyer explains that if he takes a position, for instance, and says, I will not, it would come back to Parliament. And he knows that Parliament would do that.
He has taken a position. It's not a position that we like, but he has taken a position.
And that position
is that we've been injuncted, so I'll wait for them.
That's a position. In my view, I think
isn't that position what has landed us in this impasse?
No one was about collaboration. I quote a slightly different view. You see, that sense provision of the constitution can be collaborative, but I think the purpose was for the executive also to checkmate Parliament. Because imagine if the Parliament had offered powers. This one would have been law by now. But we all know that they are. You see, the parliamentarians themselves, they're also scared. I can't believe it, because you took a vow to protect our liberties. You understand? Yes, I have my own position on gay, and which I'm not afraid to say on air and speaking. You understand? But the law isn't just about the gay and LGBT. The law also is about an attempt to take our right to think, our right to speak. You understand? And so where this law has come, first of all, our parliamentarians failed us when they all, without asking the necessary questions, without thinking about issues that concerns, they are taking away our rights. All said, we agree. Fair deal. But that's the purpose of the concept of separation of powers. So the president, you're supposed to checkmate the parliament, and you checkmate them with your power to assent. So why don't you say, okay, you know something? This is my position. Let's say I don't think Ghana we are for LGBT. However, there are elements in the law that I do not agree with, and I think unless you amend those things, they are not going to assent. It goes back to Parliament, and then you understand. But immediately you attempt this injunction things, you are running away from the issues. You are running away from the issues. You are running away from the authority the people of Ghana have given to you.
See, that is right, because even after the 7 days for determining whether or not you will assent, you have 14 days in the event that you refuse to assent, to explain why. So 14, that's 21. So 7 plus 14, 21. So the president alone has 21 days to make a determination. And then plus the third option of referring to. So that's about so if you calculate, put them all together, you have about 50 something days.
But hold on a minute. But if you add all of that and you add another 3 or 4 months in court,
exactly,
you run out of time.
So there's no application, it's not application.
Yes.
To prolong this.
You run out of time.
We need lawyer.
Yes. Let me tell you.
To prolong that, when Alan Chamatin becomes president, then now I will see.
So Amma, for me, right? I think that we must conduct ourselves civilly.
Right.
And we must operate within the confines of law and respect each other's boundaries. That's all. I think that, you see, this impunity and flagrant disregard for independence, for me, is quite shocking. That you, as Anti-LGBTQ, you think that you have that authority to put pen to paper and to write
For the
president of the Republic of Ghana, instructing Parliament, who, by the way, is the same as president, because we also voted for the parliamentarians.
He's instructing number 3.
Yes. Do you understand? No, in fact, technically he should be number 2.
Oh, number 3.
Technically he should be number 2.
Number 3.
Then you write a letter to
Number 3.
the Speaker of Parliament that he should kindly desist. Who are you?
Cease and desist.
Who are you? Who are you? You see, so I mean, so I think that we should respect, each other's authority. But you see, there's been a letter written by the Attorney General to Parliament, I think for the purpose of clarification. And when the Speaker of Parliament decided that, pursuant to the injunction filed by Dafemepo, he was refrained and restrained from approving for Parliament to approve the nominees, right? He responded to it, and I think it's important to read the letter so we can all comment on same. This is not a court document, so we can read it. Not so.
Go ahead, Conrad.
He said that
in court.
the matter is in court, but I'm just responding to what he himself has written to Parliament. Okay. And once the media is seized with the document, it's a public document. We can comment on it. Because he says that DSS, so this is not to the court. He's writing I'm officer of the court, I'm not in court, I'm on TV, and I'm speaking to a letter written by the Attorney General to our Parliament House. Decision to hold the approval of ministerial nominees presented to Parliament in light of suit number so and so. Then, respectfully, I'm aware of statement made by your esteemed self in Parliament on 20th March 2024, in which you communicated the inability of the House to continue to consider the nominations of His Excellency the President in view of the pendency of what you stated as an injunction motion on notice seeking to restrain the Speaker from proceeding with the vetting and approval filed in the suit referred to above. In furtherance of my role under Article 88 of the Constitution and bearing constitutional responsibility for the conduct and defense of all civil proceedings against the state, including Parliament, I am constrained to draw your attention to some observations made. So it is not a court document, observations made from a study of the suit in question and the results of a formal search conducted at the registry of the Supreme Court today. The action filed by Mr. Dafemepo, Member of Parliament for South Dine, consists of a bare writ of summons. Sina, please, are you here with me? Yes. No statement of case in support of a writ has been filed as mandated by Supreme Court Rules 1996 CI 16. It is thus correct to say, respectfully, that the suit is not properly constituted in accordance with Rule 46(3) of CI 16. Such an action will be struck out. Struck out. Listen to the language of future. Such an action will be struck out. Okay? Where a statement of case in support of the plaintiff's writ is not filed within 14 days. So what does that tell you? Are you preempting what the court will do? Then he proceeds to say that the plaintiff has not filed an application for interlocutory injunction seeking to restrain the Speaker from proceeding with the vetting and approval of the names of the persons submitted by His Excellency the President, or indeed any other interlocutory relief. Thus, there is nothing before the Supreme Court which may constitute a restraint or fetter on Parliament from proceeding with the approval of ministerial and deputy ministerial nominees presented to Parliament by the President in accordance with Articles 78(1) and 79(1) of the Constitution.
Right. Right.
It's just 5 points. I'll be done right now.
Please be done quickly, Kwame.
Please find and attach the results of the search. And if you look at the search, see that maybe you can read that later.
It's okay. I mean, let's rush with it. Please.
Okay. I mean, so then, whilst it's true that a relief stated on the writ filed on 18th of March 2024 referred to above purports to be an order of interlocutory injunction restraining the Speaker of Parliament from proceeding with the vetting and approval of the names of the persons submitted by His Excellency the President to Parliament. It goes without saying that same is not an application for interlocutory injunction. Every application for interlocutory relief in any of the superior courts as is tried must be by a motion specifically filed and praying for the desired relief. The mere statement on a writ of summons of a prayer for interlocutory relief is inconsequential and of no effect. It does not constitute a pending motion for such a relief, and no one is required to take notice of same. In any event, it is pertinent to indicate that the substance of Mr. Dafemeko's suit is a challenge on the power of the president to relieve ministers serving in his government of their portfolios and reassign them to different ministries. It has no bearing on the approval of persons newly nominated by the president as ministers and deputy ministers and duly presented to Parliament for approval in accordance with Article 79(1). In light of the foregoing, Parliament, in my respectful view, has no inhibition in proceeding with the approval processes for the ministerial and deputy ministerial nominees. There is no risk of a prejudice to the authority of the Supreme Court in determining the substance and essence of the suit filed by Mr. Dafemeko. My question is very simple, and I ask a very harmless question. How did he arrive at this conclusion? He's giving us reasons, yes. He's giving us provisions, yes. But you cannot make determinations on behalf of the court.
Yeah, but there's one very critical thing he said. One very critical thing. You see, the fact that you bring a writ, and the writ you say you are seeking for an injunction, won't qualify for the principle that says that the notice of an injunction is as good as an injunction. You must also take steps to bring an application.
I agree.
So if Dafemeko, but he said that Dafemeko hasn't got an application.
What I'm saying is that, but before seeing this, I've seen a statement of claim. You have a copy of it.
An application. So beyond the statement of claim,
yes,
you must also make an application to the court for an injunction.
Yes.
So if so on your rate you can be seeking for an injunction.
Yes.
But that won't qualify for the principle that says that a notice of an injunction is as good as an injunction. Yes. You must. So the federal should have gone ahead and then filed a motion or an application for an injunction.
Yeah, I think that was filed.
No, he said that it's not filed.
No, that's filed. That's filed.
No, his
that's filed. That's it.
It's done today.
Fantastic.
But you see,
what Dan was saying was that it wasn't filed. So I'm sure.
You're not getting my point. No, I'm not going into the merits of it. I won't go into the merits of it.
I'm in agreement with you
because
you are talking about procedure.
Yeah, procedure.
That's what you're talking about. Procedure.
But the law spells telling you that contrary to what
the Attorney General is saying, procedure has been followed.
Probably at the time when he filed this letter,
procedure had not
filed,
or he had filed, but he was not seized with the information.
Exactly.
Right.
But that's the point I'm making.
Right.
That you see, and I'll be very because he has 7 days to file, and you do wait
to file, not the application.
No, he himself admitted that when you file a writ, it must be accompanied by a statement of claim. And in the search, it was only the writ that was found. There was no statement of claim.
I'm in agreement with that. But that's not the issue I was raising. No, he made another issue. But he's saying that there's no inhibition.
Application for interlocutory
what would have constituted the inhibition was this application.
Right.
All the rest is saying.
Right. So now we know that application has been done.
But see, my question is that in such a situation, what ought to be done? Must you write a letter to Parliament?
Listen, what it means is that we are all playing politics.
We are not playing politics.
No, not us here. I'm talking about the organs of state.
Yeah.
Right? I'm not talking about us here. It's pure politics. This is not law. This is pure politics.
And coming with this, I noted it down. See, we must be careful. Otherwise, we would veer from the realm of rule of law to rule by law. Because what they are doing right now is to use the law as a tool.
Yeah. That's gymnastics. That's political gymnastics. Using the law.
And who suffers, Kwame?
We suffer.
We suffer.
Right. Okay. So now here's my question. When we had a hung parliament, all of us were excited. Right? We're excited because I was exceedingly excited. It seemed that we were going to have a real parliament where issues were going to be debated based on the issues, not based on numbers and based on partisanship. When we had a Speaker of Parliament who was not chosen from the executive, but was chosen from the minority side. That was also interesting. I was like, oh, wow, there's promise for this parliament. I have to say that I agree with people like Nana Komia when they say that this parliament has not lived up to the expectation that we had of it. We are a few, months to the end, so to speak. We are going to get into the election on the 7th of December. Do you think that finally, perhaps, this parliament is waking up to the opportunities that it had? And more importantly, the expectation that we had of a more vigorous parliament, of more debates, of more issues, is this an indication that perhaps that would have been terrible for governance, ultimately?
I mean, I think, and then I think we have a very strong speaker. And we must be very thankful for having a speaker like, as in, you may not agree with him, but we have a very strong speaker. But as whether we have a strong parliament, that one, I don't think we have a strong. You
don't think we have a strong parliament?
I think we have a very strong speaker. I think we have a very strong speaker.
So strong man, not strong institution.
No.
Okay, so then let's answer my question. Is this an indication of what we wanted? What we wanted by way of being excited that we had a hung parliament? Is this what a hung parliament means?
No, because we were
and is this good for governance?
No, we were hoping that for once we will have a parliament that will do their job, as in to serve as an oversight over the executive. And I don't think the hung parliament was going to answer the question because of the nature of our constitution, where majority of the ministers must come from parliament. Parliament would never be strong, or a parliament had never been strong. But we thought that because we had equal numbers, then at least we had an opportunity of having a parliament that could give the executive proper oversight. You understand? But to give the executive proper oversight, it's not about having 137 parliamentarians. You still have about half of the MPs who, because they want to catch the eye of the president, want to do their job. I think we need to be bold and amend our constitution and have proper, strict separation. Unless we do that.
Separation of powers.
Yeah, we all need, in my view. So we need a parliament where the MPs know that, listen, I'm a parliamentarian. I'm supposed to check the executive, you understand? And not be undermined or by your desire to catch the eye of the president and get something.
So you don't believe in the fluid nature of the three organs?
No,
because it has been argued, and I forget the names. There are authorities, political scholars who have argued that for smooth governance, it is important that the executive and the legislature merge at some point.
Yes, and what merges them is the interest of the country. That's the merging.
No, in personnel.
But you see what?
Even in personnel.
And so you see, you want government to run, but you also want there to be proper oversight. It's like in every company you have controls. In every company that's worth a sort, they have controls, and what the controls seek to do is to checkmate. So you can't say because or because the controls have the propensity of, let's say, slowing down things, you're going to throw away the controls and allow. No, you will crash. You understand? So Parliament, in a properly separated governance structure, what Parliament does is to be a control over the executive. Immediately you have a system where which says that majority of the MPs must be from Parliament. You understand? And so you have MPs who really go to Parliament, not because they want to be a control.
You mean majority of the ministers must be from Parliament?
They go there trying to catch the eye, so they don't do that proper control.
Right.
For 32 years, we've had an executive without control.
Right.
You understand? And I'm saying to be able to give that control, you need to have straight separation. Now, what will converge them is their shared interest, and their shared interest is Ghana, is a country, to see that the country runs. You understand? Right. So for me, we shouldn't compromise that control bit on the altar of, because for 32 years we've had no control. What has government run?
Right. I want you to come in. Unfortunately, our time is up. You have to so even economic, we have to
so. I'll finish off by saying, quoting Edmund Burke, who says, "Yes, you elect me as your representative, but when I go to Parliament, I represent you through my mind and not as a mouthpiece to do your bidding. And so the question is, what sort of democracy do we want? What sort of representation do we want? And once we answer that, then we'll be in a position to either tweak, amend, or fashion something that addresses all of those critical points. I, for my part, will not say that I've ever felt represented by my member of parliament, ever. And I'm not about to tell you where I live, but she knows herself. And I would say that possibly in this parliament, she's been the most abysmal MP that this country has ever seen. And for her to have the temerity to seek re-election, that was to add insult to injury, to consider us as idiots within her constituency. And good riddance to her. She knows herself. Thank you.
I think we know her too. I think we know her too. Kwame, please come in.
Well, let me also conclude.
Wow, our time is so far gone. I'm sorry, Kwame.
So that's indicative.
So wrap it up for me. Do a nice summary for me, Kwame.
Then let me leave it because
Kwame,
because I was not.
Oh, Kwame,
no, then let me leave it.
No, please go ahead.
No,
we want to hear you. We want to hear you, Kwame.
So what I want to say, I think it's not divorced from what they've put forward. Clearly, we have a very polarized, overly partisan parliament, for which reason we are unable to, get the full benefit, of what parliament should present. I am particularly disappointed in the minority, especially in this parliament, because I thought that, granted that they pulled parity with the majority in terms of numbers, they would have acted, as an in-house check on the majority. But what happened? I mean, all the ministers who were nominated were sailed through. No proper questions were put to them. We didn't elicit or evoke the right answers from them. They were joking on many occasions. You had occasion to even complain that when they were questioning them, they were asking very silly questions. They were laughing all over the place. They were not serious about, So I think that we have not really benefited from this. And you see, let me tell you, what happens with hung parliament is that if you don't get the right people there, they will use that as an opportunity to make money from the executive. So when there's a bill to be passed, which bill benefits their executive, they will go into some form of deal with them. I'm not saying that's what happened, but clearly, for most of the bills which have passed, some of the bills are passed and they say, we didn't even notice, like the bill on the law on the tax on sanitary parts. They passed it without even noticing that they passed it. They passed it.
And the president
so clearly, we have a parliament that's they are unserious, and I think we need serious people, serious-minded people who are very passionate about the country to go to parliament and represent the people. And I think Mr. Albright mentioned the fact that some of these parliamentarians have been re-elected, or some of them are still contesting to be re-elected. And the people who are even now representing some constituencies, like they've taken over from the old folks, right? If you even listen to them, you will puke. They are empty. They don't know anything. If you ask them why you are going to parliament, they don't know why they are going to parliament. They don't even understand what happens in parliament. So I think that generally we have a problem as a country, and we must begin to ask ourselves the burning questions. Why do we vote for parliamentarians? Do we vote for parliamentarians so that they will come and pay for our children's school fees? Or we vote for parliamentarians so that they can change and shape policy? Those are the questions we must ask ourselves.
Absolutely.
And if we do that, then we will allow Parliament to do its work. Then if we do that, then is it 70 or 50% members of Parliament or whatever that has to come from Parliament? Yeah, majority that has to come from Parliament, right? Would mean that they will do their work knowing that they have the support of their constituents. That even if the executive brings or proposes a bill, and they think that the bill is detrimental to the development of the country, they can oppose without fear or without let or hindrance. Because now, They cannot do so because, have you forgotten all those who supported Alan Chemantin?
Please wrap up for me. Please wrap up
Adomako
for me.
Kisi is out of parliament because he's openly supported Alan Kojo Chemantin.
Please wrap up for me.
You get my point? So, I mean, generally, we must eschew overly polarized partisan politics from parliament, and parliament can work for the betterment of the people of Ghana.
Absolutely. I agree with you completely. Who is winning? Speaker or president? Who is winning? Speaker is winning. Who is winning? Speaker is winning. Speaker. Okay. Right. Thank you for watching. This has been our show. I will see you tomorrow. Bye.
Truly African.